Hello and welcome to another episode of Disqualified Dads. I am your host, Coach Farouk, and I'm joined by my co-host, that family law guy, Mr. Ryan. Today we're going to be talking about domestic abuse protection orders. Mr. Ryan is going to give us a lesson and the history into these orders and all the nuances and ins and outs. So today's class, Mr. Ryan's going to lead. Let's go.
Let's go. Okay, chap. The reason we're doing this one, the reason we wanted to talk about this is because domestic abuse protection orders, also referred to as domestic abuse protection notices, are currently being tested, piloted here in this great land of ours. And so we thought it'd be quite useful just to spend 35 minutes or so just giving you the history of where they've come from, what it is that the pilot is currently exploring, but more importantly, where they're going and what are they going to replace, and that's quite key. So let's get going. So before I start talking about domestic abuse protection notices, I'm going to talk about domestic violence protection notices. Now, these came into play in 2011. They were actually rolled out nationally 2014, and they're a result of the Crime and Security Act of 2010, which said that the police would have this new power referred to as a domestic violence protection notice. A notice can only be issued by the police. An order can only be issued by a court. So the domestic violence protection notice was handed as a new instrument to the police. And what it did was it gave the police a fairly quick, flexible, short-term tool that they could use in order to protect victims of domestic violence. Particularly, and this is quite key, particularly when there wasn't enough evidence to charge a perpetrator or a suspected perpetrator, but they just needed to put some protection around the victim. So they had the power to almost instantly issue a domestic violence protection notice. Remember, notice comes from the police, order comes from the court. The protection notice lasts literally 24 to 48 hours. And then they have to, within that time, the police have to get into court in order to get a magistrate to escalate that notice and turn it into a full-blown domestic violence protection order. A domestic violence protection order can last from 14 to 28 days. So they're still quite limited. It's a weapon that the police can use in order to protect somebody in the short term. So when the Domestic Abuse Act 2021 came forward, so we're racing forward 10 years now. So when the Domestic Abuse Act 2021 comes out, it has included within it the Domestic Abuse Protection Order. And this is a move on. This is an escalation. This is a progression from the Domestic Violence Protection Order. And I'll tell you why. The reason why is we realized in this great land that domestic violence is actually just one part, one tiny element of the domestic abuse regime, of the domestic abuse spectrum, which comes in, because abuse comes in many forms. It comes in the form of violence, but it also comes in the form of financial abuse and sexual abuse and psychological abuse, emotional abuse, etc. So we decided within the Domestic Abuse Act 2021 to broaden that particular order, that protection instrument, and we created the Domestic Abuse Protection Order and the Domestic Abuse Protection Notice. I say again, notice is offered back by the police, order is offered out by the courts. So it is currently being piloted. The pilot has run from 2024 through to 2026. So it's being piloted in half a dozen places around the country, Manchester being probably one of the biggest, and a couple of the provinces south of the Thames in South London are currently testing out the Domestic Abuse Protection Notice, referred to as a DAPO, and the Protection Abuse Protection Order. So what are they? How do they move? How have they moved on? Their ultimate aim, if they get rolled out nationally, it is highly likely that they will, is they're going to replace this patchwork of existing orders that we've already got. Because currently we've got the Domestic Violence Protection Order going back 10 years, that we've just talked about. But we've also got restraining orders, which can only be issued by magistrates or judges in the criminal court. We've also got occupation orders, which are the instrument used within family court in order to remove somebody from a property. We've also got non-molestation orders, again, used by the family court in order to protect a victim or a suspected victim by essentially building an invisible fence around him or her in order that the perpetrator can't get near them. So we've got all those instruments currently. The plan is, if it's successful, that the domestic abuse protection notice and or order is going to replace all of those. So all of those are going to be swept away.
So
that is
ultimately,
jump in. Yes, that is the long-term.
So ultimately, they will now be merged into one order that covers all 5 aspects of it, and that order, I presume, will be used across criminal, civil, and family courts broadly.
Correct. You are absolutely right. The thing that makes the domestic abuse protection instrument, be it the order or the notice, the thing that makes it quite unique is that the protection order can be issued by the family court, the criminal court, or the civil court. Okay. It is available to all 3. The notice continues to be exclusive to the police. I was going to say the order can be issued by any of the judicial court systems. That makes it quite unique. So plan is that the notice, the protection notice, is issued by the police on the spot in order to create immediate short-term protection around the victim. So it can exclude an abuser from their home. It can prohibit contact with the victim and children. It can create a geographic zone that excludes the perpetrator. So it does all the things that we are familiar with in terms of non-molestation, occupation orders, and indeed restraining orders. But it does it under one order. Yes, sir.
Okay, look, question. So I want to clarify this for the audience and for myself now, because I wasn't aware of this power of notice that the police had. Yeah. Now, so this notice, you're saying this goes back to 2010. The police have had this power where they can issue this notice on the spot when they attend a call, and that can last 30 days.
Yep.
Okay, so how come we've never, I mean, with all the people I've spoken to, all the call-outs that the police get to, incidents, how come, I mean, I've never even heard of this. Like, I mean, is it used very often, or is it just something that's not used as often?
They don't use it. The reason the police don't use it is because the notice, the domestic violence protection notice, can only last 48 hours.
Oh, 48 hours.
And then they have to have it converted into a protection order issued by a magistrate. So they have to have it converted at that point in order that it can then last between 48 hours, obviously, and 28 days. So it's still quite a limited instrument. So unfortunately, from the police's perspective, and I've never spoken to a police officer about this, but I can second guess what they're going to say. They're going to say a lot of paperwork for very little gain. Hence the reason they still pursue the non-molestation, encouraging people to take the non-molestation order route, to take the restraining order route, to take the occupation order route, because the impact of those, the expiry date on those is significantly longer. You know, the best before date can run out to a year or more. So that's the problem. That was one of the major issues with the domestic violence protection notice and or protection order, is it's so limited in terms of its timeline, in terms of its life. Doesn't get used.
Okay, so you know this notice, right? So I've just had a thought. Because this notice is linked to a domestic incident, right? Domestic violence, domestic abuse, right? Would it only apply between couples, or could it apply within 2 people living under the same house, or 2 lodgers, to mom and dad, I was going to say brother and sister, 2 brothers, 2 friends? Do you know what I mean? Like, how far?
I know exactly what you mean, and we're going to come to that when we focus down on specifically just talking about the domestic abuse. I'm going to explore how it is you get one, what the criteria is for getting one. So we're going to come to that. So what you've done there is you've run it out and you've got popcorn quicker than you should have done.
Apologies for taking it back. I get too excited. Everyone knows.
I appreciate that. I appreciate the excitement, but let's just rein it in. So yes, we will come back to the criteria, but at the moment we're just exploring this progression from a domestic violence order that just frankly didn't work, through to the domestic protection order, which is currently on pilot, and as I'm about to explore, is actually being quite warmly regarded by all the authorities and by all the agencies. They're quite liking the early results from it.
Okay, before you carry on, just want to say, guys, like, subscribe, follow, and share. If you are going through the family court system, reach out to myself or Mr. Ryan, and we can support you through the system, coach you through every stage and step of the journey. Watch some of the videos that we have created previously on non-molestation orders, fact finds, and we do live streams every Sunday, normally 8:30 p.m., live Q&As to help support all of you through the system. So like, subscribe, follow, and share. And yes, Mr. Ryan, carry on.
Thank you. So we've moved on. So the domestic, let's just recap. So the domestic violence protection notice can only be issued by the police, as we know, only lasts up to 48 hours, as we know. And then they have got to get it converted. Otherwise, there's nothing. They've got to get it converted by getting into a magistrate's court and having it converted into a domestic violence protection notice, which will last up to 28 days. So still incredibly limited. We realize that's a problem. And clearly, we don't like this instrument because nobody's using it. So we move on as part of the 2021 Domestic Abuse Act, and we create the Domestic Abuse Protection Order and Protection Notice. The difference being we've replaced violence, obviously, with the word abuse. Why have we done that? So, like the Domestic Violence Protection Notice, the Domestic Abuse Protection Notice can only be issued by the police. They're the only people who have that power. And they can provide it on an immediate short-term basis. The order, so the conversion from notice to order, can be done by applying to the magistrate's court or the family court by way of providing flexibility. The application to go to an order can be made by the police. It can be made direct by the victim in the same way as you can apply for your own non-molestation. It can be made, this is where we start to make a difference now, because it can also be applied for by third parties. Now, what do I mean by that? What I mean by that is social services can make the application. But here comes the interesting bit. Your mum can make the application because she's frightened for you.
Stop. Do you mean the mother-in-law?
I mean, well, not in your mother-in-law.
Not my case, but like someone's case, like.
But exactly.
I ain't got a mother-in-law, but like the mother-in-law could apply.
A relative who believes that, one of their relatives is in danger can make an application for a domestic abuse protection order. It does not have to just be the police or the victim, which is currently where we really are with non-molestations and the violence order. Anybody almost who is connected, and we're going to talk about connection in a bit, anybody who is connected with the victim can make an application. Okay, so what else? What else is right about the protection order? Shoot.
Right, okay, so if anyone can make this application, right, yeah?
Providing they're connected, and I'm going to explain.
Providing they're connected to the perceived victim. Now, let's just make this a little bit, it's the real life application for a second, yeah? So, say some lady is an abuse victim from home. Mum knows she's in a bad relationship. She struggles, husband's a bit aggressive, whatever, violent, possibly. Mother-in-law, not mine, but that individual's mother-in-law, father-in-law, brother, I said not the victim, so the victim's mother, father, brother can apply. Now, let's just say for a second, in the family court world as we know it, let's say, so for example, I'm a victim or I'm a perceived victim. Or let's say I'm in a situation where I am in a relationship with a narcissist. I've got no one's going to believe I'm the victim. But on my behalf, if my mother, so let's say a father, a man, his mother or relative would apply. As we know, in the old system, it's very difficult for a man specifically to get a non-mol against the mother or an occupation order against the mother, or the threshold to prove that, to secure it will be highly difficult currently as we know it. So under this order, will that still be the same? So the application and the system, the application as we have it in society and family court currently, does the application, will it still be the same? So the mechanism is different, it's under one umbrella, but will the application change? This is what I'm saying. Can anyone use this, mother or father, to their advantage? Basically,
yes, exactly that. The application process will be that, using your example, daughter is in an abusive relationship, or indeed son is in an abusive relationship. It cuts all ways. So daughter or son is in an abusive relationship. Their mother is aware of it. The daughter or the son does not feel empowered to be able to do anything about it, because obviously they're trapped in this relationship. The mother can make an application for a domestic abuse protection order.
Okay.
On behalf of their son or daughter who is the victim of abuse.
The chances of, say, their son getting it secure, is it the same as it is currently with the existing non-mol and occupation? That's the question.
The early indication is it is much more gender neutral. And I'll
yes.
use that phrase. Yeah.
Yes.
The early indication is, and I'll talk to you in a minute about some of the statistics of what they've rolled out already. So the early indication is very gender neutral. So you apply for the protection order. You can do that through a magistrate's court or a family court, giving you, as I say, giving you more flexibility. The police can do it, the victim can do it, or the third parties if you are connected, and we'll talk about what connection means. But they can do it as well. So it broadens the people. CAFCAS can do it for you. Social services can do it for you. A doctor can do it for you. So there's a whole broad audience now who are now looking into this abusive relationship and are empowered to do something about it, where currently they are not. So the protection order lasts longer than the violence order. It's not limited to just 28 days, which the violence order is. It has the potential to be potentially indefinite.
Oh God, are you serious?
You can put a protection order in place forever.
I don't know. That's scary. I'm not going to lie. That is sending shivers down my spine.
You can put a restraining order in. You can't with a non-mol. You can't put a non-molestation together in place forever. It has to have an expiry date. A restraining order you can put in place indefinitely, currently. And the protection order, the abuse protection order, you can put it in place indefinitely if grounds support that.
Okay, hold on. Slow down here for a second. Yeah, we've got to dissect this for a second. But if the protection order, if the current non-mol and occupation order fall under the protection order, how does that cross over? Because, I mean, we can say, look, restraining order, we can still have them, this and that. But for those who have lived under a non-mol, those who have lived under an occupation order, those who have just been lost in the system and have survived this, and the destruction that goes along with this, let alone the mechanism, this mechanism itself is what destroys the relationship with your child. It contributes heavily to destroying that relation, the initial damage. So the question is, how does that look to you now with the protection order? So considering what happens with the non-mol occupation order now, how it's used, how relationships are destroyed there, how it's used against father predominantly, how does it, if the protection order has that power, how does that look in practice?
Well, the protection order does have that power, and the protection order actually, as I'm about to describe to you, the protection order actually has more power than the non-molestation and the occupation order and the restraining order. Because the protection order, aside from the fact that it can be put in place indefinitely, albeit that there has to be review dates. It can't just be, that's it, it's stuck on you for the next 50 years, live your life. It has to be reviewed every 2 months, or every 12 months or every 24 months. There has to be review dates in it, but it can still, exist indefinitely. There's issue, there's problem number, well, it's not a problem actually, there's the reality number one. But it also has much broader conditions, such as the domestic abuse protection order can prohibit contact with your children. So it can block that as part of the order. It can also mandate that the perpetrator has to attend behavior management training and behavior management programs. So whereas currently, to get to that, you've got to go through fact finds, and et cetera, and eventually somebody says you need to attend some training, you need to attend a bit of realignment, because you're a perpetrator and we want to change your behaviors. And let's assume for the minute that we are dealing with real perpetrators. Let's not drift off into the world of guys who are wrongly accused or women who are wrongly accused. Let's stick with genuine for the moment. So genuine perpetrators, as part of a domestic abuse protection order, can be immediately stopped from seeing their children. No further requirement to go to court. They can be immediately mandated to attend domestic abuse training, domestic abuse remedial works. That's all part of the process. That's all part of the process. And that's in terms of accelerating the system, the current system, to protect people. And let's look at it in the positive. To protect people, that acceleration of the system, and currently the pilot says it's working, is excellent. It's an excellent thing.
Okay, look. Okay, I can go with that. I can accept that it is there to protect people from harm, right? But no one's denying this is a good thing. The intent is good and is accelerated and it has more power. And okay, so let's just go with that for 1 second. So the next question that naturally falls on the back of this is, what is the threshold of evidence required before they stamp this against a potential perpetrator? What is the threshold of evidence? Because this is a serious, like I said, we're here to protect people, but we also have to protect people having this order, what's the word I'm looking for, exploited against them.
The threshold is, and it's a good question, the threshold is the same as the criminal threshold. So it has to meet a civil standard, as we call it, rather than the balance of probability. So the presentation of evidence has to be pretty thorough, has to be pretty substantial in order to secure the order. They're not just handed out willy-nilly. And as I've said many times, I have a major issue with non-molestations because I fear that they are handed out like sweets. This particular order, this new order, which is going to ultimately replace the non-molestation order, is much more robust, in my view, at this stage, at the piloted stage. Now, like all things, it will get diluted, it will get eroded, and the edges will get knocked off. And then suddenly it's perhaps not quite as clean and sparkling as we currently looks. But at this stage, I see it as a good thing. I see it as a progression away from a number of issues that currently exist in the regime of trying to protect victims.
Okay, look, so that is obviously a good thing. If it's gonna go down the road of criminal court standards, the threshold of evidence for criminal court standards, then it has to be substantial. So the question I'll ask you is this: mother-in-law, let's use me as an example. My ex-mother-in-law applies for this order against me. We go to, so they secure this order against me. I presume it's the same as they will dish it out and they say you've got to represent yourself with 28 days. You've got to go to court before they decide to stamp it off.
Challenge, all the usual stuff is there, yeah.
Well, I wish I did have an opportunity, but let's just presume that let's just say for argument's sake, it's not in East London court, it's in a good court and you get the opportunity to challenge. So you go there in 28 days. And she says, the classic, yeah, judge, you never gave me any spending money, this, that, blah, blah, blah. I said, judge, here's statement 1, statement 2, statement 3. Look, every month I'm dishing the cash every month. Bang. Judge will say, okay, rubbish. Then the classic one, yeah, but judge, when no one was around one day, I was in the kitchen washing up and he threw the bag of rice or the pasta across my head. This is the problem again, isn't it? Or he gets really angry and aggressive. I get scared. I don't know if he's going to hit me and he's unpredictable. He threw pasta at me, like the bag of pasta. This is where the he said, she said comes in. And it's that argument that it is difficult to prove or disprove. And that's where these orders are done on the back of in the family court. So how do you see that playing out if it requires substantial evidence?
Well, I think it'll be, certainly judging by the pilot notes that I've been reading, it will be much more robust. So my belief is that it'll be much more just. It will be put in place very quickly in the first instance because it is there to protect, and you don't have time to explore the minutiae because you're trying to protect a victim. So it will be put in place. But then the person who has got it lodged against them will have the opportunity, as everybody does currently with non-molestations and occupation orders, to challenge it, to test it. And that will happen, as I say, very quickly off the back of the order. But if the court decides that having applied the civil test, that there is sufficient evidence to promote it being in place, they will leave it in place, and then normal rules apply. We then go into full, very normal child proceedings where we try and work out who's telling the truth, who's not telling the truth, yada yada yada, and eventually we get to an outcome. So this is let's not confuse what this is. This is not an instrument by which parents are having their children ripped away from them. This is an instrument by which children and victims, and let's assume them to be genuine at this stage, are being protected by a system that looks to be more efficient than the current mechanism, which has too many options in it. You know, should I go down the domestic violence protection route? Should I get a non-mol? Should I get an occupation order? Should I push out and try and get a restraining order? And it's just a bit too confusing. So in terms of the pilot so far, let me just find the statistics. Bear with me 1 second. Here we are. So in terms of the pilot so far, and I'm only going to use Greater Manchester, which is one of the big pilot areas. There's a number of areas being trialled, but I've got data in front of me for Greater Manchester. So between November 24 and March 25, which is when November 24 being when the pilot started, there have been 119 domestic abuse protection orders issued. Okay, now that suggests that there's been a fairly decent uptake in this particular order, and that the mechanism is currently operational and working. The upside from the police's perspective is that we have removed this. There's only one type of domestic, and it's domestic violence. We've removed that because this order covers all manner of domestic abuse. So coercive and controlling behavior, you know, threatening behavior, harassment, yada, 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 all covered by these options. So at the moment, early indications in Manchester are good. The police's comment, and I'll tell you what the police have said about it so far. The pilot is seen by the police as a tool to better protect victims, including in cases where physical violence has not been present, but there is a risk of ongoing abuse of some other form. So psychological, emotional, etc. So the police are quite warm to it, which can only be a good thing. And also all the other stakeholders who are in this world, family court, social services, CAFCAS, doctors, you know, all of those stakeholders are also very warm to what is happening with this, because what they're hoping and what they see, and to be fair, having looked at it from, as I have done recently when I've sort of caught up with it, all of those stakeholders see that it's going to simplify what is currently a very complex landscape. You know, because I've got non-mol and I've got occupation orders, and I've got restraining orders, and I've got domestic violence protection orders and protection notices. That's a very complex landscape. It's going to remove all of that. It's going to allow much earlier intervention, so we can protect victims at the get-go. We can protect children at the get-go. But it still provides, and this is important for the person who's being accused, it still provides a very clear path for them to be able to have opportunity to challenge this, and obviously demonstrate whether it is or isn't appropriate for them to have it in place. I like it as a mechanism. I think currently it's probably wrong to say I'm a fan, but currently, you know, I like it as a mechanism. I think it is going to be popular. I think it's undoubtedly going to be rolled out nationally. That's almost guaranteed. Because the early scheme, there's another 9 months, I think it is, on the pilot. So I think it'll probably be 2027 realistically before it gets rolled out nationally, and then you will see, you know, all of the others fall away. So you'll see non-mols drop away, etc., etc., and everybody will be reaching for the DA1 form, which is the application form.
Okay, so look, they're going to pilot it, like I said, for another 9 months. Yeah, so I mean, by then they'll have enough data to decide whether this is sufficiently effective or not, or whether they could, whether the jury's out on it or not, right? Let's just say, for argument's sake, 9 months. By then, they should have sufficient data. So I think we need to revisit this end of 2026, end of 2026 or early January 2027. We need to revisit this at that point and then give a full assessment and evaluation on it. Because for me, on paper, yes, great. And I just want to highlight again, we do not support any sort of abuse by anyone to any other human being, domestic or otherwise. We are here to support genuine victims of domestic abuse and to ensure they get the help and support that is needed. But at the same time, we do not support people who take advantage of the system just to get back at each other because the relationship's broken down. So I just want to clarify that. So yeah, for me, until I see sufficient evidence that it's not being used as a tool like the previous orders, as we have seen, against one party to another as a mechanism just to gain the higher ground, gain advantage. So until I see clear evidence of that, I can't say either way. On paper, though, the intention, what it does, and it's the fact that it simplifies it might make it. I think the processes in the courts, if you have an occupation order, a molestation order, and a child arrangement order all running at the same time, more documentation, more admin, more paperwork. And I think that causes more confusion in the system, causes more jam and backlog in the system. So surely they're trying to streamline it. So that should ease the process and shave some time off from a practical standpoint, from what I can see. And that's what I hope it will do ultimately. But yeah, thanks for the insight, Mr. Ryan. Yes, please continue.
Yeah, so I said I was going to explain connected, because connected is quite key to the domestic abuse protection order, as in you can be connected and you can apply for one. So let's talk about the application routes. It is, as always, victim-led, but it's also third-party connected. So what that means is that a victim can apply directly to the family court or indeed the civil court. There is no court fee, just as there is in non-molestation, no court fee, because obviously they don't want to put that financial barrier in place of somebody who's trying to protect themselves. But applications can also be brought by people who are connected to the victim, and that includes a direct relative, mum, dad, brother, sister, uncle, auntie, can all make an application in the name of the victim. A social worker who is associated with the family, perhaps associated with the children, and has a concern, he or she can make an order on behalf of the victim. And then there are a number of other what we refer to as specified third parties. So if the matter is already in family court, CAFCAS can make an order application in their name. A doctor can make an order application in his name. The school can make an order in their name on behalf of because they're concerned about the children. So it really does open the door to people be able to do it. Now, obviously, the other side of the coin is that the police still have their power. The police still issue a domestic abuse protection notice, and they've got to seek within 48 hours, excluding Sundays and bank holidays, according to my notes. They've got to seek a magistrate's court in order to convert it from a protection notice to a protection order, and they've got to do that within 48 hours. Now, the police have direct access into the magistrate's courts, so that's something they would be able to do with absolute ease. But what the police can also do is the police can apply for a domestic abuse protection order without issuing the notice first. So they can make a direct application to a magistrate's court and say, we just want this to go straight to notice, and we want this to go straight to notice now. And just as social services can go to the family court and get an almost immediate, within the hour, hearing if it is necessary in an emergency situation, so the police can do the same. So they could secure a protection order same day without too much issue at all. It can also be initiated by the court. So the family court, the criminal court, the civil court, they can all make a domestic abuse protection order during ongoing proceedings of their own motion. So what does that mean? What that means is, let's look at the family court example. We're in the middle of a hearing. The judge is sat there, he's listening to a matter, he's got children in the matter, he's got a mum, he's got a dad. He can see that one of these is a victim of abuse, but nothing has happened so far. He can see that they are clearly a victim of abuse. He being the judge, he could also be a she, but the judge of their own volition can make a domestic abuse protection order there and then against the person in the room that they perceive to be the victim in order to protect them. So they can do that. In criminal proceedings, so we've now got suspected perpetrator up in court, possibly for their remand hearing or for the first hearing in their process, because they're about to be criminally prosecuted for beating up their partner. Doesn't matter who, doesn't matter where we are, beating up their partner. Again, as part of that process, the judge can take the decision to protect that partner by putting in place a domestic abuse protection order there and then. And again, in the civil courts, perhaps not many examples, but maybe in the civil court, there's a matter running on, possibly two former partners fighting against each other, suing each other over something or other. And there, if the judge feels that one partner is vulnerable, they can make a DAPO, domestic abuse protection order, there and then. So it is much more versatile, much more versatile.
Yeah, it does seem. I think it seems like it's a bit of a multi-tool. That's the word. It's not a single tool. It is It's a very versatile multi-tool. It's like a Swiss Army knife, many uses and many ways to get to the end result by many different parties and organizations. So we're going to have to see how this plays out. Yes, but it does seem like someone sat down and thought about this. And
indeed. Yeah. I'd say they've given this a lot of thought, and I'm just going to keep feeding you the detail because here comes some more.
Oh, there's more. Right.
There's more. There's more. So the domestic abuse protection order, it can prohibit contact by any means. It can create exclusion zones around a home, around a workplace, around a school. And it can force a requirement for one party to leave a shared home. So it has all of that power. What else can it do? Perhaps more positively, it can instruct and direct the perpetrator at which the order is leveled against that they must attend some sort of behavior change training or therapy. It can instruct substance misuse, mental health, and it can also name a responsible person to supervise compliance. So what does that mean? What that means is it might say to the perpetrator, you have got to report on a weekly basis to your doctor. You have got to report on a weekly basis to the police. You have got to report on a weekly basis to a social worker. So a responsible person is appointed to supervise. That's one of the mechanisms that is available. It's not necessarily going to be used, but it is available. Now, here's an interesting one. When the court issues the domestic abuse protection order, they can impose electronic tagging.
Ah, I see.
In order to monitor curfew and exclusion zones. And this will be the first civil order which uses electronic monitoring and electronic tagging in order to monitor compliance. Now, it can be time limited, as we've said already, but it can also be indefinite.
Bloody hell.
The courts can vary it, they can suspend it, they can discharge it, they can make it on an interim basis. They can say, whilst you're in child proceedings, perhaps this will remain in place, or for the next year, this will remain in place, or while the children are in education, this will remain in place. So they can make these parameters by which this order will stay. So it's a versatile tool, a very versatile tool. In terms of the police, it can only be issued by a senior officer. So not everybody can hand them out. Police, it is a senior officer who sanctions a protection notice where he or she believes that there are reasonable grounds of abuse and a necessity to protect a suspected victim. And as we've said already, they've then got to get it to magistrates court within 48 hours in order to convert it from a notice to an order. Let's talk about breaching one.
Go on.
Okay.
Yeah, it's getting interesting.
They have criminalized the breaching of a protection order. So if you breach a DAPO without a reasonable excuse or an acceptable excuse, i.e. being accepted by the police when they come and knock on your door, it is a criminal offence.
Mm-hmm.
It is indictable to up to 5 years in prison.
Really?
Yep. Also, on a summary conviction, you can pick up obviously suspended sentence, or you can pick up a fine. It comes with power of arrest. So you can be arrested if you breach your DAPO. And it tended to be a primary, what we call cross-jurisdiction protective tool. That sounds grand. What it essentially means is we're getting rid of all the non-molestation orders, restraining orders, all the others, all this mix, and just replacing it with one instrument. But it's one instrument, as I said right at the start, it's one instrument that is available across all three judiciaries. So family, civil, criminal, and it sits across all three. So it's an interesting tool. It's coming our way. It's already in, as I say, it's already in pilot going very, very well. Police are liking it. All the agencies are liking it. People are particularly liking the fact that obviously the victim doesn't have to be strong enough to make the application. And that can often be a problem when you're a victim of abuse. They don't have to be strong enough because somebody else can do it on their behalf. Somebody who is connected to them, their mother, their doctor, their social worker, they can do it on their behalf in order to empower the victim. And that I'm particularly, I'm very positive about that. I particularly like that because obviously having worked in this sector for years, I'm aware of how difficult it is for victims to make that decision that today's the day I am going to secure change.
Mm.
So domestic abuse, protection orders, protection notices, heading our way. Within the next 2 years, they'll be nationwide. I can almost guarantee that. And we all need to be aware of it.
Yeah, I think the more that I've heard on this and the powers it has, the 5-year prison sentence, the indefinite electronic tag, I've got to be honest, I don't know if it's a trauma response because I've been on the receiving end of a non-mol, an occupation order. You know how I lived off grid for 2 years. I know how easy these things can be pinned against a father, so to speak, want of a better word. Great idea, like you said, for genuine victims of abuse. Let's not genderize it. Let's just say genuine victims of abuse. They deserve all the help. They need these mechanisms. But until I see the application until the societal position that we have with this is the proper balanced way to say this without creating a divide. Until the societal position of how we perceive both genders evolve, hence then the same perception is evolved into the judiciary and the family court system. It's just a mechanism that's evolved with a lot more power, and I think a lot more reach and a lot more easy to apply. So the point is that the Swiss Army knife is not a bad tool, but you might have now with that knife, there's more than one way to hurt someone. That's what I'm saying. So it's there to protect you, but it can also be used as a weapon. Currently, as we know it, so that's my only gripe with it is the societal position on how we perceive both genders currently, which is reflected in the family court. Until that aspect changes, This is now a Swiss Army knife instead of just a individual tool. So that's where, for me, that's where it sits for me until I see that change there.
Okay, I get that. Yeah, so pursuing that analogy, the non-molestation is a single-bladed knife. It can only cut you once. The domestic abuse protection order has the potential to be a Swiss Army knife, using your analogy, which means it could cut you 10 different ways. And I get that. And we do need to be mindful of it. But as I say, this evening, obviously, while we're focusing on there are victims of abuse, and it is a wonderful protective mechanism, and I get it, and I get the instruments that are within it, like the electronic tagging, which they don't necessarily have to use, but it's available to them, like the indefinite time length, which again they don't have to use, but it's available to them. I get it. You're right. Unfortunately, and it's appropriate that it's called abuse, because every mechanism that is available, somebody will find a way to abuse it. I talked long and hard about abuse in the family court system, abuse of the legal aid system, abuse of those who allege abuse. So yeah, I recognise the need for concern about it. But on a positive level, for those who are true victims and who are truly vulnerable, I think it's a huge step forward.
Absolutely. Listen, at the end of the day, we don't condone any sort of abuse against anyone. And if this order protects those victims who need the support and help, then, let's hope it serves them as they need it. That's what I'll say. And I quite enjoyed this discussion and this education. Thank you, Mr. Ryan, for informing us.
Thank you, sir.
Guys, if you enjoyed this video and you want to see more like this, more discussions around the different mechanisms and orders and any other process around the family court system, let us know in the comments. And if there's any specific topics you want covered in videos like this, we're going to make a lot more videos like this, 10 minute, 15 minute, half an hour, 40 minutes. Let us know what you want. We'll make these videos and we'll get this information out there. Anything to add, Mr. Ryan?
Not at all. Just stay safe, people. Stay safe.
Thank you, guys. We will see you on the next one.